Now let me just be clear. In your presentation today and in your written presentation, you have alleged that unlike Governor's Council, you have alleged that the request from the Lewistown radio station for the PSA was not made until after the governor actually made the PSA? Is that the request came not before, but after he made the PSA?
You read the record.
Right.
With all due respect, the administration is in charge of the National Guard. They got tanks and airplanes and Apache helicopters. This is a real simple thing to make real clear, and it scares me that they can't get the story straight. We received a request in early March. No, we received the request in late February. Then they also have the email. The most objective, independent piece of information is the email from KXLO itself, and it's dated after the date the governor admits that they did this. It's dated March 6th. They did this March 5th. So no, I'm not creating it. I'm just pointing out to you, this is the record that they've given us.
So let me ask you this, in terms of going forward from this hearing. If you are allowed to proceed, either postpone ruling on the governor's motion or deny the governor's motion, but allow you to go ahead and do your discovery. After you depose, I guess the three players are Lynette Lark, who worked for the radio station, Sarah Elliott, who worked for the governor's office, and the fellow who was the communications director for the...
Mr. Zeller.
Mr. Zeller. It seems to me like those are the three players. If you are given an opportunity to depose those people, and you come up with nothing, that after deposing Zeller, Sarah Elliott, and Lark for the radio station, it's pretty clear from the depositions that either the statement or the request for the PSA either came before or came after. Is it in your mind that issue? Is that issue finished then? What I'm trying to think, what I'm asking you is, what's the need to hold a hearing here? It seems to me that you've got three witnesses that are potentially critical in this case. If we depose them and we find out from them that the governor is correct, that the request came from the radio station before he made the PSA, isn't that issue now, that fact issue, off the table? Do we have to hold a public hearing for further elaboration on that issue?
Well, Your Honor, as I've tried to make clear in the brief and today and in the proposed facts I've given you, there is no exception for the governor to violate the law if he's asked to do so.
Right. So that's a question. That's just a question of law then. And then we can get on to the question of law. But what I don't want to do is prolong this proceeding. That if in denying the governor's motion for summary judgment, that basically what we're setting in motion is a long protracted discovery period of time, then automatically followed by a public hearing. I don't see that, well, that's necessary in this case. And I'm just trying to ask you, you're the one that's opposing the governor's motion for summary judgment, and you're the one who's saying, well, there are these fact questions that are still up in the air that need to be resolved. What I'm trying to figure out is, when are you going to be satisfied that those fact questions have been resolved so that we can make a ruling on this legal issue without going to a public? Is there any time you're going to be satisfied without going to a public hearing?
Your Honor, I'm satisfied today if you go on the prima facie facts that I put before the court.
But let's say that I don't rule, I don't grant a summary judgment. So the case proceeds. At what point is the Republican Party, what your client, going to be satisfied that we've looked at the facts long enough that we can now make a decision of law on the question?
Well, if you're asking me, am I going to let my friend make policy arguments that this was a legitimate function of the office, that he didn't use it to campaign, that he didn't...
I'm not going to. I'm just going to ask
that's
you.
the discovery goes to...
I want you to answer this in a yes or no question, and I want you to answer it just in a time frame. How long do you think it will take you to conduct the discovery that you are requesting on these outstanding fact questions? A month? 6 months? I mean, how long are we going to continue to deal with these alleged outstanding fact questions? It seems to me that there is some question about getting this issue resolved one way or the other, and I'm very hesitant to go along with your argument that there are these outstanding fact questions that we need Lynette Lark. We need to depose her. We need her testimony. We need her. We need to know more about who came up with the slogan, Montana on the move. Was that the radio station? Was that the governor? Was that the Democratic Party? National Ag Month. Did that come from the radio station? Did it come from the governor? I mean, resolving these fact questions, I'm trying to figure out if we're going to resolve the fact questions, what is your best guess in terms of a timetable so that we can get this case resolved?
You could decide it today, Your Honor, if you're going to decide it on the true facts to the prima facie case. If you're going to go to this issue about what happens elsewhere, if you're going to go to these secondary issues, and by the way, I didn't raise those, Your Honor. I didn't raise those issues. The governor used those issues to excuse them. Assuming that the governor is available and makes these witnesses available, I would guess 30 days would be sufficient to depose them. But I think you're in a position today, Your Honor, and this is what I've argued in my brief and I've argued again today, you're in a position today to ignore all that because there is no exception. There is no exception for important public policy. There is no exception that it's going to hamper the governor. The legislature considered that, just decided on the facts before you. And as I briefed, and as I've said in the brief, these are secondary issues. But if part of your conclusion, if you are leaning, as you said in your opening after the governor's council spoke, that you think it's confusing, or that the governor's got a good point that this could hamper government, then I think the party needs the opportunity to show the illegitimate nature of what's going on here. It's raised. I think it's preposterous that this could be a legitimate function, and I do believe that discovery would prove to your satisfaction, Your Honor, that that's the case.
I think I understand. Okay. Let me just say, if we take those issues off the table, if I take off...
Which would be my preference?
Yeah, let me just say which issues. If I take off the table the issue of who came up with National Agriculture Month, we just don't talk about that anymore. We just talk about the government made a public service announcement with staff, and it was sent to radio stations. We don't talk about who came up with National Agriculture Month. That's not relevant to our inquiry. I'm willing to do that. I'm just trying to decide here today, are you saying that's all right with you? That you don't need additional factual inquiry into that matter?
I think I am.
That it is irrelevant. Because that, I think, is the governor's argument. The governor's argument is, I mean, to some extent, I'm hearing two different things, but really I think the governor's saying, governor's council, as I hear the governor's council saying, who came up with National Agriculture Month is irrelevant to deciding this issue. And I'm prepared to accept that. It's irrelevant.